Hello, everyone. Thank you for joining us today for our webinar on PFAS. With me, I have a pre-recorded Dr. Francesca Ginley, who's a Policy and Advocacy Manager at the Marine Conservation Society, who will provide us with an update on the policy landscape. Francesca has gone on maternity leave early, so she has pre-recorded her section. Next, I'll pass to Hélène Duguy, a lawyer at ClientEarth, who will provide an update on litigation, looking at current trends in PFAS-related lawsuits and future expectations. And lastly, I'll pass to my colleague Thalia, a senior investment analyst at Planet Tracker, who will dive into the financial implications and assess the material financial risks and impacts. Finally, we will end on a Q&A session. And just very quickly, I'm sure you're all aware, but I just wanted to take 1 minute just to introduce Planet Tracker for anybody who is unfamiliar with the full breadth of work that we are doing. So Planet Tracker is a sustainable finance think tank conducting research on nature-related risks and opportunities. We focus on the key drivers of biodiversity loss, specifically land and sea use change, exploitation of natural resources, pollution, and climate change. We provide in-depth research reports on each of these topics, covering a range of industries and themes, as you can see on the slide here. And we're a not-for-profit, so everything we do is for the common good, and all of our research is publicly available on our website or on your usual financial data platforms. So with that being said, I will go to a pre-recorded Dr. Francesca for her section.
So if you're seeing this, apologies, I can't be there in person. It means I've started my maternity leave early, so I'm recording this in advance just in case. But I'm Dr. Francesca Ginley, and I work for the Marine Conservation Society as their Policy and Advocacy Manager for chemicals. So thank you very much, Thalia and Planet Tracker, for having me along to talk all about PFAS policy. So just for a bit of context, Marine Conservation Society have worked on PFAS for over 6 years now, and the real cornerstone of our work on PFAS is evidence. So we do a lot of our own evidence collection. We've worked with the University of Portsmouth. Most recently, actually, just this week, or last week, we published a study with the University of Portsmouth on PFAS in Langston Harbour and the wider Solent area. We've also worked with watershed investigations to gather data of PFAS around the UK in animals. And then we use that evidence and evidence that other people have collected and turn it into our policy asks. So we always make sure that all of anything that we're asking of policy is based very much on the evidence. So we work exclusively in the UK. For this presentation, I've included wider policy from the EU and the US, but our work is purely in the UK. But we do keep a very close eye on EU policy with PFAS specifically, just because that is, at the moment, the gold standard. So that is the bit that we want the UK to follow the EU. So just as a to set the scene of UK policy with PFAS, the UK in general has very much slipped behind the EU ever since Brexit. So we've got fewer chemical restrictions in general, fewer authorizations. The whole of UK REACH is behind EU REACH. And that includes not keeping up to speed with some of the restrictions that have gone through or some of the proposals that are going through in the EU currently. In fairness to the UK, that has actually started to change more recently. So the first thing that happened was the firefighting foam consultation was launched earlier this year, and in there they're basically talking about or consulting on banning PFAS in firefighting foam. And overall, we were really happy with the consultation. It looked exactly what we would be calling for. It was very much in alignment with what the EU are proposing, with just a few a few timelines that were a little bit longer that we weren't that happy with. Overall, without getting too technical, but overall, we've been happy with the direction the UK are starting to move in with their policy, in part because they're using the OECD definition, which a couple of years ago they developed their own PFAS definition, which not only complicates things because it makes it different to the rest of the world, but it also means that they were missing out a vast number of PFAS from the group. So now they seem to have transitioned very much to using this much broader OECD definition, including in the firefighting foam consultation. And then more recently, they published their PFAS plan. So that was published in February, March of this year. And the plan overall is very the sort of the scope of the plan and the evidence behind the plan is brilliant, and it really addresses the concerns that we have with PFAS, like their persistence, their mobility, and their widespread nature. What it doesn't do is address those concerns with appropriate action. And so many of the actions that are included in the plan are very much focused around monitoring and research and further evidence gathering, which, although is important, it shouldn't be standing in the way of restrictions. And in the action plan, there are no restrictions, no commitments to any other restrictions. There is mention of a possibility of a consumer product ban, but aside from that, there are no other restrictions. In the plan, there is also talk of potential alignment with EU REACH, which, as I'll go on to in a second, would be brilliant because it would then mean we would align with what the EU are doing on their PFAS policy. So like I've already said, the all chemical policy within the EU is covered under EU REACH, and then what was supposed to be the equivalent in the UK REACH. There is talk at the moment of it being quite a popular option for the UK to align UK REACH with EU REACH, which would be brilliant because it would mean then that any decisions that are made at the EU, we would automatically be making as well. So it stops us having this massive gap of regulation and restriction. So for PFAS specifically in the EU, in 2020, they published their chemical strategy for sustainability, and in there was a commitment to banning PFAS from all non-essential uses. And then in 2023, the universal PFAS restriction dossier was submitted by 5 EU countries, so Denmark, the Netherlands, Germany, Norway, and Sweden. And then most recently, RAC and SEAC have published their opinions, which was the sort of last bit of the process that we've been waiting for. And both were very much in support of this broad PFAS restriction. So by a universal restriction, we're talking of banning all PFAS under this umbrella, all persistent PFAS under this umbrella, from all uses that are not essential to the health, safety, and functioning of society. And obviously, 2020, 6 years ago now, the process has been going on for quite a while because it is the first kind of restriction of its type, banning like a big, broad group of chemicals in this way. So in order to sort of speed things along, France and Denmark have actually introduced their own consumer product bans. So they've taking it one step ahead of this universal restriction, whilst all the details are being sorted out. In the US, it's a much more piecemeal approach. There is no federal action that's being taken really, other than on drinking water and I think in food packaging as well. And then other than that, it's all very much state by state. So there are a lot of states that have banned, again, mainly consumer uses or firefighting foams. That seems to be the main ones that either individual countries or individual states in this scenario seem to be going. So New York have banned PFAS in firefighting foam. Maine have introduced a lot of restrictions on consumer products, but it's very piecemeal. Like I said at the beginning, I work very much solely on the UK, so I don't know the ins and outs too much of the state of it in the US. But they are, there are some states that have gone extremely far and have progressed further than the EU even, because they've actually introduced restrictions. So we really want to see this universal PFAS restriction, specifically in the UK for the Marine Conservation Society, but we see this as the best option to deal with PFAS, because if you group PFAS into smaller subgroups or you ban them one by one, you are always going to have this regrettable substitution effect, where just because the group is so large, you have to look at them as a whole, and then have sorry, my brain's gone. In occasion, you may need there to be derogations if PFAS are needed for a very specific medical use, for example, or for a very specific PPE use. But that should not mean that PFAS are then used in the round in consumer products and all these other products where there are alternatives. So that's exactly what we're calling for in the UK. And then, aside from restrictions, we do want to see more monitoring. We do want to see more research. It just cannot be done instead of restrictions, because we're running out of time. So thank you for listening to my recorded webinar. I've included my email address, but obviously if you're watching this version, then it means I'm no longer at work. So I've also included my manager's email address as well. So if there are any specific questions about PFAS policy, please get in touch with us. But otherwise, I hope that was interesting, and thank you again to Planet Tracker for inviting me along.
Okay, great. So hopefully the audio was fine for that. Next, I will pass to Hélène. Hélène, over to you.
Thank you, Chris, and hi, everybody. My name is Hélène Duguy. I work for ClientEarth as a lawyer. I've been working for 6 years on chemicals-related legislation and litigation. So Planet Tracker kindly invited me to present you a little bit about what's happening on the side of lawsuits and litigation in the world, but with a specific focus on Europe. So next slide, please, Chris. So I will just set a bit the scene, how it all started, how the litigation on PFAS started, what's the status quo now in Europe, what's happening, and the likely evolution of this litigation landscape. Next slide, please. Great. So you probably all know now, because PFAS has become quite a big topic nowadays. You've probably watched the movie Dark Waters, so you know all about that. But so everything started in the US with the Tennant versus DuPont court case that was filed in 1999 in the state of West Virginia. And what happened with this lawyer called Rob Bilott is that it really triggered a lot of different lawsuits across the US. And we count now over 10,000 PFAS-related lawsuits, and different actually lawsuits in that regard. We have damages for environmental contamination, but we also have a lot of actions alleging misrepresentation, consumer fraud, greenwashing, and more recently, personal injury. We also have in the US quite a lot of cases targeting the supply chain, including retailers, food outlets, packaging, manufacturers, producers of PFAS-containing products, including cosmetics, textiles, and others. So that's mostly the landscape of litigation in the US at the moment. What's very striking about the US is not only the number of cases, but it's also the settlements that it has led to. Overall, the cost of PFAS litigation in the US is considered to exceed $100 billion at the moment, and this is only gonna increase. Next slide, please. So the US has been definitely an important baseline, let's say, for initiating and making also known the context of PFAS contamination and also the responsibility of polluters in that big crisis. So in Europe, we're still at early stages. We have around 80 active cases, but as I will explain, case law is actually on the rise. compared to the US, we have a wide diversity of claims in terms of type of litigation. So we have administrative, civil, criminal cases, and we have also cases that combine different types of legal pathways. We have, let's say, for about 20 years now, quite some environmental contamination cases. For example, in Belgium. We also have product liability or personal injury cases like in the US. Some of the most noteworthy cases have been in Sweden, but we have in other European countries as well. Recently, we've had a surge in criminal cases targeting companies' directors or executives or the company itself. In Belgium, but also in Italy, in the Netherlands, and that's something that we haven't seen yet in the US. We've also had a type of class action model or like mass claim type of actions that have been launched in France and the Netherlands. And very recently, actually last week, there was a case launched against the French state by a French NGO for the inaction on PFAS. So as you can see, there is a wide diversity of cases, and compared to the US, the case law is still emerging. The judges are still a little bit conservative because we're testing the ground and we're testing what's feasible also in terms of access to justice and standing, but it's accelerating at a quite fast pace. Also compared to the US, we have cheaper settlement. That's also because of the nature of the law. That's pretty different. But what's very striking in Europe is that lawyers and communities, municipalities are really understanding litigation in a more strategic manner, which means that the objective often is not just to get compensation for damages or like have the polluters support the remediation, but the idea is also to force company to substitute PFAS and to change this PFAS business model. Next slide, please. So what are the consequences very concretely? So obviously we have direct financial costs, which are very high in the US, a bit less high in the EU. The litigation processes are costly generally, but also the settlements and the sanctions. We have increasing insurance premiums, capital diverted to fund crisis management and the remediation, so quite a lot of costs for companies in that sense. But we also have as importantly, in a way, indirect costs, so a high reputational impact. If you think of criminal cases, that's actually even worse. The loss of consumer trust, of course, and access to capital markets more difficult, etc. What we can see also in terms of consequences for companies is that proactive compliance is not enough anymore, also because historical contamination oftentimes means that PFAS liabilities persist even after phase outs. And we've seen this in different European contexts where companies have actually phased out their production of PFAS, but liabilities persist still. We see also very interestingly that all supply chain become at risk. So not just the upstream producers, the one actually producing and emitting PFAS into the environment at sites, but also all the rest of the supply chain that is involved in the processing of PFAS or actually handling PFAS containing products at the end of the chain. We also have even some waste managing companies that are being also put on trial or at least challenged for how they deal with PFAS. Very interestingly, also the criminal sanctions that, for example, in a recent case in Italy, that we have actually personal liability. And so potentially very heavy sanctions that can go to imprisonment. And indeed also quite a symbolic sanction here because of course, the use of criminal law is really a signal of a breach of social contract. So it's also something that European lawyers have been using more and more in the context of PFAS pollution. Thank you. So how can we think about the likely evolution of the litigation landscape? So obviously the PFAS situation hasn't stopped. The PFAS pollution is still there, and it's actually there is no at the moment, there is not a regulation that would actually really minimize the risk posed by PFAS, which means that PFAS pollution is still continuing. And that means we will continue to have more cases of people that are faced with the consequences of this pollution, but also municipalities, for example, that want to get support, financial support for remediation because of the costs of the depollution. We are expecting more diverse also litigation and wider ambition, as I said before, especially in Europe. There is a kind of strategic component to PFAS litigation. What we're noticing as well is that litigation becomes easier for communities and authorities because more and more cases are being brought to the court versus it's becoming more of a risk for companies. Also because the cases are becoming well known, the information on the case is actually being communicated across the courtrooms. Judges get familiar with the cases. So we have multi-layered cases, new claimants, such as workers, municipalities, new defendants, not just the big well-known producers like 3M or Chemours, but supply chain actors and downstream users. And we also have more of a global component. Case law is not just about national stakeholders at a certain point. It can address also the problem of the global supply chain. And also, of course, we expect case law to go beyond the US and Europe. And obviously, we expect that litigation is going to push transformation for the companies that produce or use PFAS. A likely evolution is also hopefully that litigation is going to lead to more regulatory oversights, that we will have new and stronger regulatory frameworks that will force compliance, but also for companies that will force PFAS substitution. And we hope that there will be also consequences in terms of polluter pays. Less opportunities to cheat. So obviously the power of litigation is also to pierce the corporate veil and to increase the scrutiny of some of the liability shield maneuvers that we've seen for some companies exposed by PFAS litigation, such as moving business outside Europe, asset transfers, etc. We also see quite some cross-jurisdiction coordination among communities, among municipalities, among lawyers, but also among judges and the different authorities that are being involved in litigation. And obviously a massive financial exposure that's hopefully going to lead to some change within companies. So that's it for that. It was quite short, but I remain available for questions if needed. Thank you very much.
Thank you very much, Hélène. And now I'm going to pass to my colleague, Thalia. And before I do so, I just would like to say, if you do have any questions, please do pop them into the Q&A and we will try and get to them at the end of the webinar. Otherwise, we'll follow up afterwards. Thanks. Over to you, Thalia.
Yeah, thank you, Chris. Yes, I would like at this point to build on what Francesca and Hélène have already outlined. And mainly I would like to focus on the economic cost of delay and what PFAS means in practice for investors. So if we can start, yeah. I am not going to I'm not going to talk about the environmental and health harms. My point is that those harms do not remain abstract. Because PFAS persist, the resulting costs can emerge years later through litigation, remediation, tighter compliance requirements, and pressure on water systems and public budgets. That persistence is what makes PFAS economically distinctive. The liability can outlast the original commercial benefit. That is why we believe that PFAS risk patterns follows a similar one with asbestos and tobacco, that they are known for with long tail liabilities. If we go to the next slide, please. So, as the litigation is already large, and we heard from Hélène that the rising trends, and the only thing that I would like to emphasize here is that in US, PFAS litigation has become one of the biggest environmental mass torts in US history. And the 3M example, the settlement of over $10 billion shows the scale of liability is now being recognized. And also we saw that in Europe, the trend is grows as well. Recently, European Commission published a study that suggests that if current PFAS pollution continues to 2050, cumulative societal costs in Europe could reach at least 440 billion, while tackling releases at source would be far cheaper than relying mainly on water treatment. Next slide, please. So, because of all of this, we recently did an analysis on the litigation risk exposure that investors could have in association to PFAS. And we mapped over 1,000 listed companies and their associated, over 5,000 associated facilities. And what we found was that the risk is not evenly distributed. So roughly, 1/3 of high-risk facilities sits within just 20 parent companies. So this is in part a concentrated producer problem. But the costs do not stay there. Downstream users can still face local contamination claims, remediation costs, and community pressure. And that is why earlier disclosure and targeted intervention actually matters. They reduce the risk that costs are simply shifted onto water systems, customers, and communities. Next slide, please. So with our analysis, we released a tool that looks like what you see in your screen, and it is meant to estimate facility level exposure by combining legal case information, regulatory context, emissions, and corporate disclosures. So we started with the PFAS producers, and then via trade, we connected them to other industries. Very quickly, I would like to point out that the tool is not trying to predict exactly who will be sued next. Instead, it is designed to give investors and any other users the opportunity to identify hotspots, compare holdings, and start integrating PFAS into valuation and stewardship work. Next slide. So, as I mentioned earlier, PFAS costs travel downstream, and in order to show that, we looked into two case studies, the litigation exposure and what this means in financial terms. And the first case study is Chemus, PFAS producer, chemical producer with a legacy in PFAS exposure. And we estimate that around $1.1 billion of cumulative PFAS-related charges they are facing since 2019, which is equivalent of the 17% of the company's enterprise value. Now, the second case study is Worldwide Wolverine. Worldwide Wolverine is an American footwear company. They did not manufacture PFAS, but they bought PFAS-containing treatments from 3M, and they used it in their footwear production. And what we saw was their financial exposure was very high, with roughly 160 to 180 millions of known settlements since 2017. And this is equivalent of around 7 to 11% of the company's enterprise value. So the lesson is that the PFAS risk can travel down the value chain through product use, waste disposal, and legacy site contamination. The final slide, please. What we recommend is that investors should demand better disclosure on the PFAS use, contaminated size, provisions, and liability estimates, and they should integrate PFAS liabilities directly into valuation, credit, and risk models. They also, we encourage engagement and voting to push for a phase-out PFAS, stronger due diligence, and capital expenditure that aligns with PFAS' limited future. And basically, our takeaway is that if action is delayed, the costs tend to be shifted into cleanup, water systems, and legal liability. So earlier visibility and earlier action are likely to be cheaper than later action. And final slide. I have will send across the presentation later, and I have put here the links for our dashboard and our work. And I am aware of the time, so please back to you.
That's great. Thank you so much. I did notice some questions coming through. Unfortunately, in the interest of time, we'll have to call it there, but we will get back to you if you did ask a question in the next couple of days. But yeah, thank you very much for your time, everyone, and we hope this was useful. Take care. Bye-bye.